Is case number 103433, State of Kansas v. Gary L. Morningstar, Jr.
Chief Justice Nuss, other members of the court, my name is Elaine Esparza, and I am arguing for the appellant. I'd like to request a 3-minute rebuttal.
3 minutes is granted.
Thank you, Your Honor. This is the appellant's second time before this court. The first time the case was remanded for resentencing on the off-grid rape charge, the court ordering that because the state did not find and allege that the defendant was over the age of 18, it had to be remanded for resentencing on that sole count. When the district court judge resentenced, he also changed the sentence for what had been the primary offense, and that was the aggravated battery. The rape now became a severity level 1.
And it became the primary offense, correct?
Yes, sir. And then the aggravated battery became the non-base sentence. He ordered that those run consecutive, whereas before all of the sentences were running concurrent. And the appellant is arguing that that is outside of the statute 214720 and also this court's mandate.
If I have read this correctly, the precise pronouncement by the court was that the rape sentence was to, quote, run consecutive to the others, end quote. Is that what the court said? So there's no question that as it was verbalized, the intent was to serve the others, and then the primary offense would be served consecutive to.
Yes. The appellant, as I said, the appellant's argument is that KSA 214720 doesn't cover this particular incident because we don't have a reversal of the conviction. We just had the sentence set aside.
Well, that's not exactly technically correct because the Supreme Court has said that if you have a sentencing factor that increases the maximum term over and above what the jury found, then you have an enhanced version of the offense. So we basically reversed the conviction for the enhanced version of the crime, which would be off-grid, and remanded for the lesser version, the lesser included version.
Well, you remanded for resentencing on that sole count. And the judge did give the defendant the aggravated sentence of 186 months. He then resentenced on the aggravated battery because it was no longer the base offense.
And you have no objection to that, to the recalculation of that? I mean, it necessarily had to change the base offense, didn't he?
I think that under the statute and laws he had to, that would have been an illegal sentence. But he can correct that and reduce it, apply the correct criminal history score, which is what he did, but he didn't have to change and make it consecutive or make the first offense consecutive. He can correct that aggravated battery sentence without doing anything else. And that's what we're advocating that he should do, or should have done.
But didn't the court have the ability to make the primary, what then became the primary conviction, consecutive? That's the part I'm missing.
Well, that's what we're arguing that he didn't have authority to do.
Why not?
Because that's not covered by 21 4720, I think it's B5, that specifically states that the multiple convictions aspect of that statute applies if the conviction is overturned. We didn't have a conviction overturned. We just had a sentence overturned.
Why is the consecutive versus concurrent nature of that sentence, I mean, why is it consecutiveness and concurrent just an inherent part of the sentence on that crime?
Inherent part of the rape sentence?
Rape sentence.
Well, I believe that you anticipate that the primary offense, if in a multiple conviction case, that the other sentences are going to be consecutive to the primary or base sentence. In this case, the judge kind of flipped that on its head and made the primary or base sentence consecutive to all of the others. To correct the sentence, to follow the court's mandate on the rape conviction, he didn't have to change anything else except the ag battery. He didn't have to go one step further and make the sentences consecutive.
He didn't have to, but is there anything that prevents, I mean, I know our typical pattern, I don't know that I've ever seen this before, where the base sentences run consecutive to the other sentences, but is there anything in the law that prevents that? I mean, is it?
I'd have to admit, I don't have a statutory site that would.
Well, you might want to look at 214720B6 and B7. They aren't directly applicable, but they talk about the primary crime and, quote, consecutive sentences, appearing to distinguish the primary crime from the consecutive sentences, which makes intuitive sense, is that if you have a primary crime, it's not consecutive or concurrent with anything. It's the first one. And so that language tends to corroborate, albeit those two sections are not directly applicable here, but the legislature has used that nomenclature, consecutive sentences, to be something different than the primary crimes. You might take a look at that.
Yes, sir. I've got the statute. What sections did you refer to?
B6 and B7.
Are you suggesting that the court, once we vacated the sentence, didn't have the ability to alter what occurred at the initial sentencing as it pertains to consecutive and concurrent sentences? Is that what you're telling us?
The district court?
Yeah. When we vacated the sentence and sent it back, that implicit in that was, well, yes, the primary crime changes, but how you initially handled the concurrent and consecutive sentence on the initial sentence can't be altered. Is that what you're telling us?
That's what my position is, yes.
And why? When we vacate a sentence, it's do it over. It starts over. We vacate sentence all the time. If we find like an aggravator or a mitigator hasn't been appropriately applied, we say start over again, take evidence, and then do the sentence. We don't say you have to still do what you did initially. That's the whole purpose of vacating a sentence, is to do it over and do it right.
Well, I understand that, but when you resentence on the rape count, when you're making that consecutive to the ag battery and all the other counts, then you are changing the rest of the sentence.
Right.
You're not just changing the rape sentence.
And what's wrong with, why can't you change the sentence? It's vacated. The entire sentence was vacated. You do it over again. So your position is just the rape sentence was the only thing that can be touched in this situation?
Yes, except for the aggravated battery, which had to be changed because it's no longer the base sentence. It would have been an illegal sentence. Makes a difference of about 5 months. It'd make no difference at all if the judge
What was the,
continued with the concurrent.
My other question is, what was ultimately on the remand and the resentence, what was the controlling sentence after it was all said and done? It was 186 months on the rape.
And
you know what
43 months on the ag battery.
So he still ended up with considerably less than what he ended up with initially.
Well, yes, sir, he did.
He did. Okay.
While you've still got a couple of minutes, I want to move you over to the other issues in the petition for review because I'm a little confused about their status based on kind of what was said about it. And I realize you didn't do the petition for review, but you've got an attack on Schoonover, or do you still intend to make that attack even though you gave it, even though it was given, and I keep saying you, even though it was given up at the Court of Appeals level?
No, sir. I think the brief essentially says that that issue is abandoned.
So the second and third issue in the petition for review are abandoned, the third issue being that whether all the elements of ag battery are included in child abuse.
Well, I'd have to agree with that.
And all we care about is you want us to focus on the resentence on the rape conviction and the district court making it consecutive.
That's correct, Your Honor.
That's fine.
Do you have any further presentation?
No, I don't. Any further questions?
More questions of counsel? I see none. Thank you.
All right, thank you.
May it please the court, Chief Justice Nuss, Matthew Metcalf on behalf of the state of Kansas, appellee. It seems the issue is whether or not the district court complied with the mandate on remand, and I don't see any statutory authority that says that they didn't. I can't find any statutory authority that limits what the district court does on resentencing with regard to concurrent or consecutive once the sentence was vacated.
But those statutes, you would agree the rule of lenity says that we construe those in favor of the accused, not in favor of the state.
Yeah, if it's ambiguous, right.
And, okay, what do you, why does the sentencing scheme refer to a primary sentence and consecutive sentences as if they are two different things?
Well, 214720 talks about establishing the primary crime and the base sentence first. So that's typically what happens. This was an unusual situation because the original, the off-grid offense became the primary offense. It was already.
I understand all that, but what we're talking about is whether legally you can serve a primary offense consecutive to a non-primary offense.
214720B says the sentencing judge shall have discretion to impose concurrent or consecutive sentences in multiple conviction cases. And in that statute, it doesn't say you have to run the non-base sentences consecutive or concurrent. I think where that comes from is you establish the primary crime and the base sentence first. So just in order, that's what happens. And this was a little bit different because of the way the remand went back and the sentence had previously been handed down. I understand the wording that you're referring to in B6 and B7. I do see
and that wording does, it specifically refers to primary crime as being something separate from what it refers to as consecutive sentences. Would
Right.
you agree with that?
I do agree with that.
And so the legislature has placed the nomenclature of consecutive sentences to be something different than the primary offense.
Yeah, and I guess then if the court, and I'm not saying that the court only had authority to resentence with regard to the new primary crime of rape, but even if the court did, the court has to first establish a primary sentence.
Why wouldn't it be restricted? We have a law that says you can't modify. The court had no authority to modify any sentences except what authority we gave it in our mandate or what authority the statutes gave it on remand. Would you agree with that?
they have to comply, the district court has to comply with the mandate.
And they also have to comply with the statute that says you can't modify a sentence.
Well, when they sent it back down, they got a new base sentence. And when they got a new base sentence, then the court, under the statute, would have to establish whether the base sentences were to run concurrent or consecutive with the primary sentence. We had a new primary sentence that was vacated and sent back down, so then the court
But we
would,
had a pronouncement. We had a pronouncement originally that they were run concurrently. And so when it was sent back, there was nothing that required, in the mandate, that required that be addressed. What was required was that the rate be on grid, and because of that, statutorily, the previous primary crime had to be modified to apply a history I instead of the criminal history.
that's
Correct?
correct.
Those are the only things that had to happen based on the mandate.
Yeah, right. They had to make the primary crime, and then they had to correct the illegal sentence, which is correct.
And anything above that is an exercise of judicial discretion.
Well, my position, I believe that the court, I don't believe there's anything in the statute that says that the court couldn't run consecutive or concurrent, because they resentenced on that count. They had to resentence on that count and make it a primary offense. So the court had never sentenced on that, or essentially the court had never sentenced with regard to that count. So that would take away any judicial determination whether this should be run concurrent or consecutive. It would just take that out of the district court's hands completely from the get-go.
That makes more sense if you ignore the fact that the pronouncement of consecutive or concurrent is not applicable just to one crime. It actually is applicable to the entire sentence. It gives a longer aggregate. So it changes the way in which the crimes other than the battery and the other crimes, it changes how everything is served. So
Right.
by necessity, as a practical matter, it's a modification of all the sentences, isn't it?
Yes, and I guess when the appellant points to B5 that talks about remanding a multiple conviction case when you overturn a conviction, and while the wording is a little different, essentially we have the same outcome. We have to establish a new base sentence, and in B5 it talks about that particular circumstance, and I'm not sure, looking at the record, it doesn't look like the court relied on B5 in making its determination. The court just said, as you pointed out, I'm running count one consecutive to the other counts, and did not address or change the other counts, although essentially it changed the entire sentence, but did not pronounce it that way.
Let me ask you about an oddity that I haven't figured out, which is why the Court of Appeals went to a lot of trouble to explain why the district court was authorized to do what it did, and then at the end said we dismissed the case for lack of jurisdiction. If it doesn't have jurisdiction, it shouldn't be talking a whole lot about the merits. So which do you think it is?
I think, I understand the Court of Appeals' position that they're not going to disturb an otherwise lawful sentence within the Kansas sentencing guidelines, and that they didn't have jurisdiction, that it wasn't vindictive. I understand all that, but I think the issue is whether or not the mandate was complied with. And so I think that the appellate courts always have jurisdiction to determine whether or not the district court complied with the mandate.
And wouldn't we also have the ability to look at this if it were an illegal sentence? I kind of read the defendant's arguments to be both an illegal sentence and a failure of the lower court to comply with this court's order.
Right.
It seems to me both of those, an appellate court would have jurisdiction to determine the merits of those arguments.
Yeah, and if it's an illegal sentence, there's a statute on point that says the court can always correct an illegal sentence. And I think if it's an illegal sentence, or if the mandate wasn't complied with, I think that this court does have jurisdiction to deal with those issues.
So your position is the Court of Appeals erred when it said it did not have jurisdiction?
I think if the issue is whether or not the mandate was complied with, I think that case law supports that appellate courts always have jurisdiction to determine whether or not the district court complied with the mandate.
Right, and that's what Mr. Morningstar is arguing.
Right.
It's that, so we have jurisdiction. You would agree with that?
I do agree with that. I think case law supports that.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel. Do you have one, Justice Johnson?
No, thank you.
You could reserve 3 minutes for rebuttal.
I have no further comments, Judge, Justice Nuss, unless there's any other questions.
I see none. Thank you.
All right, thank you very much.
Thank you both for your arguments this morning. Court will take this matter under advisement.